Order. The question is that the motion be agreed to, but before we go to the next speaker, I invite David Clark to make a withdrawal.
In respect, Mr Speaker, of my previous comment in question time, as requested by the Speaker, I withdraw. Point of order, Mr.
Point of order, Dr. David Clark.
A separate point of order, Mr Speaker. I seek your considered ruling on the use of the phrase "I withdrew" and similar phrases. A quick search of the Hansard has revealed that raising questions about the honesty of members appears to have become more commonplace, and that the exact same entreaty that I used is recorded on more than one previous occasion in the Hansard with no such rebuke from the Speaker.
I'm not prepared to give an undertaking that on behalf of the Speaker that he will come back with a considered ruling. I don't think it's my place to do it. It may well be that the Speaker does in fact look at this and consider whether it is appropriate. I will, however, warn the member that speakers as far back as Statham and Oram have indicated that one has to take particular care on anything which might be a reflection on the Speaker. And alleging inconsistency of that sort is one of the things which is a reflection on the Speaker. I was not in the House this afternoon. I did not hear what happened. I have been briefed on it. The particular words used have been used in the past. There is no doubt about that. And they have also been ruled out in the past, and it is, I think, a question of context. If in fact members are alleging that a minister is deliberately not telling the truth, then the appropriate thing to do is to write a letter to the Speaker and ask for a reference to the Privileges Committee. That is, I think, a much better, it is the approach of standing orders, and members may get more satisfaction through that approach than they do by making comments which sound like they led to disorder or and cause problems for the House. So what I'll do is I'll leave it at that point. If Mr Speaker wants to make a considered ruling, then I have no doubt he will. Before we... So I will just had a quick briefing of me, and as is often my case, I've declined to take the advice. Sir William Seal.
Thank you, Mr Speaker. I feel after that intervention we need to stand for a moment of silence. Mr Speaker, I am very pleased to have heard the Minister declare his acceptance of all the amendments as recommended by the Select Committee on this particular bill, and I'm happy to also convey to the Minister that the Labour Party will be supporting this bill at its second reading. I think, considering that the committee only received 3 submissions on the bill and heard only 1, I think the committee worked really, really well in terms of attempting to ensure the clarity of the bill, and that any issues related to those who have the rights to take claims in terms of their damaged buildings or homes were being addressed. And as the Minister has rightly said, it does concern it does give the opportunity to about 70 claimants to be able to receive support through the financial package that has been prepared, provided they're able to meet the 50% mark. I want to say, though, sir, that in recognising the Minister's ability to take advice from the committee, in recognising also that this committee has generally worked to try and find appropriate recommendations, I think we also need to recognise that this came about as a result of John and Helen Osborne, who won their legal battle in the Supreme Court last year, arguing that the 10-year limitation on leaky building claims should start from when the property is issued with a code of compliance by the council and not when the construction is completed. And so, you know, we do need to recognise that and acknowledge their contribution in this, because I think if they hadn't done it, I think not only the government but all of us parliamentarians would have just forged through without due consideration of the impact on the lives of those people whose homes have been affected because of the leaky syndrome. And I think, sir, we've also got to recognise that many of these people have just gone through such a dreadful and stressful situation. And I think, you know, failing any support from their local governments, who are also facing financial difficulties, these people had no other choice but to come to government. And if it weren't for the efforts of John and Helen Osborne, I don't think, sir, that we as a parliament would have been able to look genuinely at trying to address this particular matter. So acknowledge those people in particular. I do want to say, sir, that in the recommendations that the Select Committee made, I thought it was important, sir, that the committee first looked at the three specific aims of the bill, but then made the various recommendations that I'm pleased to hear that the Minister fully accepts. The committee recommended that inserting clause 5, new section 125BA of the Principal Act, which groups together all related matters into one section, and that this definition would make it clear that a claimant must meet the contribution criteria in either clause 1 of the 2011 Gazette notice or in any other notice issued by the Chief Executive of the Ministry of Business, Innovation and Employment. There's another matter which I just want to highlight, and that was, there was some wording to the effect of, I think it said, all reasonable effort. And I think the committee found that you couldn't rely on some sort of a definition that would be made by the local council, etc., on that we had to be quite fair on people and take into consideration all the efforts that they were making to try and achieve an amicable outcome in result of their claim. There was something that the committee considered, and that was a suggestion by the Regulation Review Committee that the full content of the Gazette notice contribution criteria be inserted into the Act. However, the committee noted that the criteria are the result of PTA negotiations, and for future flexibility, we considered it unnecessary for them to be included in the Act in full. So those are really the only comments I'd like to make on this particular bill. The reality is, and I'm not trying to be political in this regard, but the reality is we need to take note of how the leaky situation occurred. It goes back to 1994 when the national government of the day decided to open it up, to free up the situation and allow the market to dictate what happens to the building of new homes. And I think, sir, the point I would like to highlight in airing that is simply the fact that this is an example of where the market has failed our communities. And so for those opponents, for those proponents of the marketplace, I think they need to take note that when they opened up the building criteria in this regard, it actually took away the role of local governments by enforcing that the quality and the nature of building materials were at such a state as to ensure that this kind of incident does not occur. And I know in the 1990s, the government of that particular time felt that the market was wonderful and that the market was the answer to everything. And, well, that's right. and I think it was Mr. Morris Williams. To his credit, though, he identified that it was he and his government, and that has been reported publicly, were responsible, that's right. And so I think the House needs to take note of the mistakes of the past if it generally wants to move forward, and the House needs to, I think, as a result of this example, recognise that the market does not provide the answer to all things. And I think when New Zealand was a mixed economy, sir, was a mixed economy, it was a country that was thriving. It was a country that enabled to have jobs for all, higher incomes. The unions played a significant role, and that is clearly different from where we've got a situation now under this national government. I just thought I'd highlight that, but as I said, we're not trying to be political here. We're simply trying to ask this government take heed of the past mistakes as we move forward. But as I said, the Labour Party will support this at its second reading. Thank you very much.
Scott Simpson. Thank you, Mr. Speaker. And with the indulgence